Hi, everyone. We'll be getting started in just a moment here. I'm going to let everybody kind of filter in a little bit. Welcome to LDA's March webinar, and we'll be getting started in just a moment. Okay, it looks like we have a steady number of people in. Welcome again to the March webinar, covering your bases, common myths and mistakes in dealing with school systems and how to avoid them. My name is Erica and I'm with LDA of America. Just a few housekeeping things in the beginning here. If you are joining us via phone, unfortunately, you won't be able to see the slides that Caitlin's prepared and you won't be able to send chat questions. At the end, there is a section for Q&A. If you are on your phone, you can hit *6 to unmute yourself. And at that point, make sure that you're not on speakerphone. Make sure that you're not, you don't have any feedback. If you do have feedback, I'll be forced to mute you again, but you'll be able to ask questions that way. If you are joining us via the webinar online, please look at the bottom of the screen and there is a Q&A section. If you have questions for Caitlin at the end of our session, please put them in there. I'll be monitoring those as we go. And without any further ado, I would like to introduce Caitlin McAndrews. She is a shareholder with McAndrews, and I'm going to butcher these names, Mahalik, Connolly, Hulson, Ryan, handling special education and estate planning matters in Delaware, Virginia, Maryland, Pennsylvania, and Washington, D.C. She's previously worked as a special educator in the Philadelphia area. Since that time, and in addition to her private practice, she's clerked for the Protection and Advocacy Group for People with Disabilities in Washington, D.C., the U.S. DOJ Civil Rights Division's Educational Opportunities Section, the UDC Juvenile and Special Education Law Clinic, the National Youth Justice Alliance, and Delaware's P&A, Community Legal Aid Society. She resides in Pennsylvania with her husband and 2 children, and I'm going to hand it over to you, Caitlin. Thank you for joining us and welcome.
Thank you so much, Erica, and thank you all of you who are joining us tonight. I know that there are a lot of demands on all of our time right now, especially those of us who are trying to juggle work and homeschooling or internet schooling or whatever is going on in this new health situation that we all find ourselves in. So I really appreciate all of you being here tonight. The topic is covering your bases, common myths and mistakes in dealing with school systems by parents or advocates. And this topic was really born out of the themes that kept coming up for me in initial meetings or initial consults with families where, you know, a parent or an advocate would tell me, and then I did X, Y, and Z. And they were, you know, felt very confident in that action, and I could understand why they felt confident in that action. And it was the exact opposite of what you would want to see from a legal strategic standpoint. So really what we're going to be talking about is all of those kind of little things that are maybe counterintuitive in advocating for our kids with disabilities with schools, and that kind of go against our gut instincts. Because a lot of the time as parents, that is the best tool that we have to go on, is our instinct and what we think is right for our kids. After all, we are the experts in our own children. I often tell parents, you know, that the school psychologist might be the psychology expert, and the special educator might be the special education expert, and the SLP may be the speech language expert, but you're the expert in your child, and that's very valid expertise that you bring to the table. And a lot of times, I would say most of the time, those gut instincts are good to rely on. The next 10 tips are areas where I find that whatever your gut may be telling you might not be accurate. And so that's kind of where this theme was born. To kind of jump right in, the very first, and I would say most often, thing that I see happening that I would say is usually not advantageous in advocating for kids is withholding information. I think that by the time a lot of people come to me, mistrust has been brewing for a while. And there's a level of distrust between the family and the school system. And obviously that can be really hard to break down And one of the hardest parts of my job is breaking that down, because I always say that while I am getting involved in a case because there's a controversy, especially for our younger kids, at some point I'm going to go away. Nobody's keeping me on retainer for the 12 years that their kids are in school. I have to leave, and there has to be a bridge built between the school and the family. And a lot of what I do is trying to mend that relationship. But the fact remains, by the time people come to me, usually that relationship is pretty broken. And therefore, it's natural for a lot of parents to want to hold back information from the school because they don't trust the school. One of the most concerning reasons that this can happen is if there's been a FERPA breach in the past, where a teacher or other professional has given out information about the student that they were not supposed to do, whether they said something in front of a class or left something on their screen that then got seen by somebody else. That's obviously a huge concern. And we can talk about some strategies for addressing that. But the other reasons that I often hear are a little bit more nuanced. So one thing that I see a lot is a family that obtains private testing and then doesn't share it with the district because they say that they want to see what the district does in their own testing to be able to compare. And I think that that's a really natural instinct. The reason that it can be a counterproductive one is, as many of us know, if the same test is repeated within too short of a period of time, typically 6 months or 12 months, depending on the assessment, it invalidates the second assessment. So by withholding that testing, what a parent is doing is denying the school district an opportunity to complete an accurate assessment themselves. If the family's test was done first and then the school district's was done second, it actually invalidates the school district testing. And vice versa, if the school district's testing is done first and then the family goes and pays for a private evaluation and doesn't tell the district that this is being done and doesn't, connect their private evaluator with the district's evaluator, then the private testing that they're paying for can be invalidated. This can be really important where a family wants to seek reimbursement for an independent educational evaluation. As many of you know, under the IDEA, a parent is entitled to express disagreement with a school district's assessment and then request an independent evaluation on that basis. And if they've already obtained the independent evaluation, they can then request to be reimbursed for what they already spent based on disagreement with the school district's assessment. If the family hasn't shared that private evaluation, or even if they haven't told the district ahead of time that they're going to get the private evaluation done, it can impede their ability to get reimbursed for that testing, which can be, several $1,000s. So that can be a very costly piece of information to withhold. The other reason that it can be harmful to withhold either outside testing, information from outside tutors, or even denying the school district the ability to speak with outside providers is we then can't hold the district responsible for having that information. So there are cases where I will see an outside evaluation or an outside provider say 2 years ago, this student needs a more restrictive placement. They need individualized research-based reading instruction, or they need, pull out scientifically based instruction in math. And I'll see that recommendation made 2 years ago and it's not followed. But if that recommendation isn't shared with the school district, then I can't go to the district and say, look, you had this information 2 years ago. Are there ways that we can say that the district should have arrived at that conclusion themselves? Sure. But it's always helpful when you have those strong advocates in outside professionals, whether that is an independent evaluator or a service provider. If we have really strong advocates there, it is helpful to share that information with the district and to enable that communication, because then if it rises to the circumstances where I'm getting involved, I can then use that information to hopefully move things along for the student. The next tip that I have is to avoid using the literal or virtual trash can. Hopefully we all have a high capacity email address like a Gmail account by now, so that you can keep all of your emails with the school. And so do that. Please do not delete any emails that you have with the school. You would be surprised at how many cases come back to communication that was done via email, because that is how we communicate these days, and maybe even now more so than ever, now that a lot of us are working virtually. So if you do have a Gmail account or another high capacity email, please just archive your messages and keep them. You never know when they're going to be useful later. If you don't have that kind of an account, typically emails are not that big. And so I recommend downloading them and storing them on your hard drive so that you have a record of them. In any event, keeping your correspondence with the school is really important. And similarly, keeping your documentation with the school is important. In particular, the most important documents that I typically want to see at the outset of a consult with a potential client is, is a prior written notice, also called a notice of recommended educational placement in some states. So that's often abbreviated either PWN or NOREP, the IEP, and the evaluation report or evaluation summary report. Those are the 3 documents that are often sent in paper form, sometimes in the student's backpack, which is not my favorite form of written communication. But that aside, those are the documents that I really like to see at the outset of a case and are really helpful for me in determining what the written evidence in a legal case may be. So I always recommend to clients to maintain those documents in particular. We, hope that school districts are meeting their obligation to maintain accurate records. And I do, if I'm getting involved in a case, request records from a district. But there are a lot of situations where I'm not getting draft IEPs or I'm not getting the final signed version. And so I do really stress to parents to keep all their documents in a safe place if at all possible. I joke that, whenever somebody starts the question, if we're talking about records, if they start the question, do you want, before I even hear what the end of the sentence is, I say yes, whatever it is, I want it, because I can always, discard information or set aside information, but I don't know about it if you don't provide it to me. The other thing that often happens, unfortunately, in cases, and I'm very lucky to not have to go to due process hearings all that often. The majority of my cases do settle, which is great. But unfortunately, I would say like 9 out of 10 hearings that I go to will be sitting there and my client will whisper to me, they're lying and I have the document that proves it. And if I don't already have the document that proves it, I haven't provided it to the attorney for the school district. And if I haven't provided that document 5 days in advance of the hearing, the chances are very good that I will not be able to use it in a hearing. So that is the other reason to really make sure that you keep everything and that you provide everything to your advocate or your attorney if you're going to be working with them. Because if you go to a due process hearing, we have what are called 5-day disclosure requirements, in which I have to disclose 5 days before the hearing all of the documents that I may rely on at the hearing. And if you have a smoking gun document that I don't know of, I can't disclose it before the hearing. The next tip that I have is not to transfer your student without notice. I've had a lot of cases where parents are looking for the school district to support their choice of a private school, and they yanked their student without any notice to the district and placed them in the private school. Again, I totally understand where, if you realize that your student is in a bad placement in the school that they're in, and you get the acceptance to a school where you feel that they will make progress, I totally understand the desire to make that switch as quickly as possible. The reason that that can be harmful in a case where a parent wants to seek school district financial support for the new placement is because if you're getting reimbursed for tuition that you've spent, if you're trying to set up what we call a tuition reimbursement, or sometimes jokingly called a place and chase case, where you place the student and then you chase the tuition, there are 3 elements that are really important to be able to legally establish. The first is that the district's program was inappropriate. And a lot of the time when parents are coming to us, there's documentation to show that the district's program was inappropriate, particularly when parents make sure to save the information, you know, when they don't use the trash can, if they've saved the documentation, we're often in a pretty good position to show either through emails where teachers are kind of anecdotally sharing progress information, or through you know, the IEPs and the progress reports, we can really tease out the inappropriateness of the district's program. The second element is that the parents have selected an appropriate program, and hopefully in whatever program the student is being moved to, they're going to start to make progress. The program is going to be more appropriate, and we're going to be able to show that you know, that new placement is an appropriate placement for them. And then the third element is the really tricky one, and that is what the courts typically refer to as balancing the equities, or ensuring that there was no unfairness on either part. And the standard of treating the school district with fairness on the parents' part is making sure to give them notice of the intended move. Typically 10 days is what is considered appropriate. And so when, you know, if a family comes to me before the move and they say, look, I have this acceptance, this is what we're thinking of doing, I, you know, coach them in terms of slowing down and making the school district aware of the intent to move the student. Because you want to make sure that you don't forego that chance to demonstrate that you acted with good faith and fairness in trying to work things out with the district. A lot of times parents have been trying to work things out with the district for a long time before they come to the point of looking to spend a lot of money to send their kids to private school, and they don't realize, look, you just need to make this last good faith showing in order to make sure that you're covering yourself and covering your base in that regard. This next one is a really tricky one that I think people don't recognize the potential negative implications of. If you, you know, have an apartment in another school district, if you have a family member in another school district, if you have a daycare provider in another district, but your student does not lay his or her head on a pillow in that district the majority of the nights of the week, you cannot send your kid to the district that you don't live in. And I see this more than I would like to. And again, I totally understand why. If you feel like you have an address that you can list in another district and you could get mail there, and it's a better district than the one you live in, why wouldn't you want to send your kid to a school district where you feel that their needs would be served better? But unfortunately, in most states that I know of, now I don't know all 50 states, but in most states that I know of, this is it's not only illegal under the the civil penalties, but there's oftentimes a financial penalty attached to it. So some states, it's actually 3 times what the per pupil tuition would be is what you owe to that district. So it can actually open you up to all sorts of liability. And as a more practical matter, because I don't usually see parents charge tuition, usually the school districts find out and just say, hey, you gotta go. And so as a practical matter, usually I don't see people end up having to pay the fines. But as a practical matter, I'm not gonna be able to advocate for your students' rights in a district where you don't live. Unfortunately, there have been cases where district officials follow a student to make sure that they're walking in the door of the address where the family says that they live. Once a lawyer comes into the picture, they want to be sure that they actually owe a duty to that student. And if the address that you're listing is not an accurate address, it makes it such that I'm not able to pursue relief against the district on your behalf. So definitely something to keep in mind. And if there is a way of, moving into that district, if I've actually had kids move to live with a family member so that they can attend a school in a different district, that's fine. But unless the child is laying their head there at night, it's really not advisable to send the kid to that district school. Excuse me. The next mistake or, instinct that I see that I recommend parents with, fight against is refusing evaluations. So again, kind of going with that first tip, a lot of times I see a lot of mistrust having built between parents and schools, and parents just saying, I don't trust their providers to get it right, or I don't trust them to get the information that we need, or I don't trust them to do the evaluation correctly. And I think that the information is going to be skewed. There's two problems with refusing to let the school district evaluate. First, if the school district is not able to evaluate, they have an excuse for not providing your child with an appropriate program. If I were to bring a case to due process and challenge an IEP, and the district said, well, we would have loved to develop a more appropriate IEP, but we weren't able to give the child all the assessments that we wanted to, and so we didn't have a clear picture of his or her needs. Even with ample evidence that maybe the evaluation that the district would have done would be inappropriate, because we don't have the benefit of that evaluation, because we don't know for sure, 99.9 times out of 100, the hearing officer is going to say, you're right, you didn't have a chance to assess the child's needs, therefore I won't hold you responsible for providing an appropriate program. The vast majority of the time, refusing to let the school district evaluate is, it sets them up for an excuse to not appropriately program for your child. So then what's the second reason? And what do you do if you do feel very certain that the district won't evaluate well? Well, the second reason that I advise parents typically not to refuse an evaluation is because when the school district evaluates, if they do a poor job, then you have that right that we talked about earlier to disagree with the evaluation and to request an independent educational evaluation. So while foregoing the district's ability to raise an excuse that they couldn't program for your child, you're also keeping the door open to getting good evaluative data. So I understand the concern that the district might not do a good job. Sometimes they do, and they surprise us, and that's great. And we have good data, and then we can move forward faster with pursuing an appropriate program. But if they don't, just know that you still have that other remedy, which is the remedy of the independent educational evaluation, often abbreviated IEE. This next one is I think really easy to occur, especially when families and school districts are getting along well. And so a lot of times this kind of information predates my involvement by a year or more, because we like to say people don't come to us for a checkup. They come to us in desperation. And so, if you think of our office, the analogous medical situation, we're not, primary care. We're not being hired on retainer. We are getting involved when people are in an emergency situation. So typically this kind of informal communication being a problem is happening like long before my involvement, because a lot of times when people come to see me, they've been trying to work it out with the district for a long time. But not always. Sometimes the situation is that last school year's teacher was great and this school year's teacher is not, and parents come to me out of frustration midway through the school year, and so it's only a year ago that we have this kind of very friendly informal communication between the family and the teacher. Well, I definitely think it's good to have a good relationship with school staff and with the people that are working with your kids, and I'm totally fine with keeping things casual. If there's anything substantive discussed, I stress to put it in writing. So even after a friendly, phone call with the teacher where they say, all right, we're going to implement some extra supports in class, I suggest to write a sandwich email. And by sandwich, I mean, the bread is the greetings. So you want to start and end with really, polite, friendly greetings of, hi, it was so nice to talk to you. Thank you so much for making the time for my child. I really appreciate this partnership. Just confirming my understanding that you are going to be meeting with Johnny, every Tuesday after school for an extra half an hour to work on this long division. I so appreciate your help. I'll make sure to pick him up at 3:30 on those days. Something like that. So you're starting and ending very nice. The meat of the sandwich is, and the meat of the email is what you want to make sure that you're documenting. And by writing it down, that then gives me the information that I need later to say, okay, look, school district, I understand that you didn't think that Johnny needed extra help in 3rd grade last year, or that you didn't think he needed an IEP at that time. But look, I have these emails confirming that the teacher was spending his own time working with Johnny after school. And that was really helping him to keep up. And we understand that that's not an obligation on the teachers. We understand that that's not a requirement. Now that he's not getting that support, he's falling behind again, and we need to look at more stringent supports. So again, there's an example that if it's not in writing, it didn't happen. If it's in writing, it's something that we can use to advance the student's case. And then the flip side of putting everything in writing is making sure that that writing is formal enough to be presentable. I say, if you're writing something, I want you to think not only about how the reader is reading it, but how a hearing officer would read it. So, I've unfortunately had a lot of written communication that is very informal between families and schools, in which there's talk of drinking, there's talk of how fun the weekend is. All of this is the kind of things that you would talk to your friends about, and it makes sense that if you're friendly with your child's teacher, you may kind of start to cross those lines, but you have to think about how it would look to a hearing officer, because in most states where I practice, I'm getting all of the emails in advance of a hearing, and you can bet if I'm requesting them, the school district's attorney is requesting them. And if he sees had a schwasty weekend, there's a chance he may keep that in his back pocket to ask about during a hearing. So it's just something that you want to think about your audiences, and use the same kind of good sense that we're teaching a lot of our students to use when they're using social media. So, understanding, okay, you may be posting this on Instagram for your friends. However, if one of your friends takes a screenshot and sends it to your boss, how do you feel about it then? Just thinking beyond the intended audience because of the permanence of the communication forms that we use. The next tip is to avoid too much anger. And I think that it's totally natural for a protective instinct to come in when disagreements arise, and to, with that fight or flight response, to go to fight. But I try to stress to parents to catch themselves, because a firm but kind parent is going to be a much more effective advocate than an angry one. To an outside observer, you always want to appear as the reasonable one. And by outside observer, I'm usually talking about a hearing officer or hearing panel. Because when an email is written in all caps, or if there's some demonstration of anger, unfortunately, for parents, coming into a hearing can be already a stressful situation, and can be a situation in which the educators are viewed as experts who have experience with the student, who are just getting into, or who are trying to do their best to teach kids. And if a parent is perceived as being really angry and beating up on the school system, a lot of times that's not viewed well by hearing officers. And I'm not saying that that's right. In fact, a lot of the times where I see these all caps emails, or I hear of parents getting, really losing their cool with the school system, it's because of horrific things that have happened in schools. And I'm not saying that the emotion anger isn't a valid one. I just really try to help people rein in that anger and put it to productive use. And so I say to, use the iron fist in the velvet glove. So you can tell I've mixed the two for this tip. So try not to use the iron glove. I say, be the iron fist in the velvet glove. You want to come across as firm but kind. And that is the demeanor that I find most successful. In meetings, I recommend that parents try to frame everything in terms of the child's needs to keep the team focused. And try, if it's an IEP meeting, try to focus on the child's needs going forward and not rehashing disagreements from the past. It tends to not be super productive. And if you end up, going to a lawyer, a lot of times they can pursue compensatory education for past violations. So especially when I'm going to a meeting with a parent, I say, let's focus on Susan's needs for this year going forward. And let me worry later about the things that have happened in the past, because it's not going to be a productive use of time at this meeting. I also am a huge advocate of using breaks. So if things become too heated, ask for a break. It's totally fine. And it's way better than storming out or saying, I'm ending this meeting. When I read meeting notes that say, the parent ended the meeting, the team remains willing to reconvene whenever the parent is willing, I know that that's totally the school district kind of stoking an already angry parent, and that the parent left because they were just at their wits' end in a meeting where they probably felt really ganged up on, because these meetings can be really intimidating. However, it doesn't always read that way to a hearing officer. So again, I really suggest, if you need it, take a break. It is totally fine to ask for breaks and totally reasonable. And again, just going back to when you are writing, when you're putting things in writing, making sure that they are, they're in a very positive tone. So starting and ending with pleasantries. And then if you have to document some unpleasant things, definitely go ahead and put it in writing, but make sure that you're keeping your tone courteous. So the alternate side of that is being the velvet fist. Remember, we're going for iron fist and velvet glove. You don't want to be a total pushover or this parent doormat on the screen that I have here. You want to make sure that you're still being very firm for your child. I work a lot in Southern Delaware, where I frequently hear, well, I just didn't want to push things because the teacher is my neighbor's cousin. And where we are, in smaller communities, I understand that instinct completely. You are friendly with the people or friends of the people that you're working with, but you want to make sure that your child is getting the services that they need. One technique that I suggest to parents who think that this may be more their tendency is to start with asking questions, because questions are not typically perceived as aggressive. They're really just helping you get more information. So, why can't we consider the accommodations that I propose and then take data on whether or not they're effective? Or would you please provide my son's progress monitoring for the last quarter before we decide to move him into a different class? My favorite is, what is the research basis for this program? Because the most recent iteration of the IDEA says that we must be using research-based programming to the extent practicable, which the courts have said does not mean to the extent that we can afford it or to the extent that we have the program. It really is there research-based programming in this area of need? And the truth is, the vast majority of areas of education, we have research-based programming. So if the school is, putting forth some math program, say, is this research-based? Okay, can I see the research basis for this programming? How do we know that this is going to be effective? Has it been shown to be effective for students with this kind of disability before? And if civil discussions don't lead to results, I say, don't be afraid to go up the chain of command. And again, you can do this in a polite way, especially if you're the kind of parent who thinks that you tend to, be concerned about rocking the boat. If you're hearing no from the teacher and you disagree, you can work your way up with a, carefully written, well-timed letter to the special education coordinator or educational diagnostician. It gets called different things in different places. Even the director of special education, if you think that, that's appropriate. But working your way up that chain, one ladder at a time or one rung at a time, can be a good way of moving things forward for your child. Again, without, if your instinct isn't to be aggressive, that's not aggressive. It's just being a firm advocate. This one I think is really counterintuitive, because we all want what's best for our kids, right? But setting the highest standards is one of the ways that school districts can kind of weasel or wriggle out of things. I hate to say weasel. As a former teacher, I don't like calling teachers names. So, but they can kind of use that to wriggle out of things, because the standard is not best. It's not a best interest standard for kids. It's what's appropriate. So the law doesn't use maximize potential. It says what is necessary to make for the child to make appropriate progress. So anytime you want to say, I'm just asking for this because it's what's best, just substitute appropriate for best. And frankly, most parents that I know, that's what they're looking for. They're not, asking for their kid to be treated the best in the class, better than everyone else. They want them to receive appropriate services so that they can have a fair chance at achieving, commensurate with their potential, which is appropriate. And then finally, I like to say to pick your battles. And I think that sometimes we can become so entrenched in in one fight that we don't realize that that's not actually the thing that we care that much about. It's almost like how I deal with my toddler. So I have two young kids, one who is very much at that stage where everything is a fight. And I have to kind of model for her saying, you know what, this is not that important to me. I just earlier today said, it's actually not that important to me what pants you wear if you wear the pants that I picked out. So we'll go get another pair of pants. That wasn't a battle that I needed to pick. And similarly, we can become entrenched in our fights with school districts. Even though we're professionals and adults, not children, we can become really entrenched, especially in the moment in an IEP meeting. You know, you may go in there with your list of things that you're looking for, but if you don't, you know, if you don't kind of do some prep work in terms of prioritizing that list, it can feel like the district is saying no to every single thing that you want on there. So what I actually recommend is making a table with 3 columns and separating your list into those 3 columns. And the first column may be things that would be nice, but you don't view them as crucial. The second things are things that you really do want to push for and you might more strongly advocate for in the meeting, but ultimately you might be willing to let go, especially if it is in favor of something in the third column, which is the things that you will fight tooth and nail for, you would go to a hearing over. And I actually find those kinds of lists really useful as a legal advocate for students, because if you come and you tell me, look, I have heard from my child's therapist, from her psychologist, from her private tutor, the thing that is going to make a difference is a one-on-one who can help facilitate social interactions. And that is the thing that I'm willing to go to due process over. It's good for me to know that, because if that's what it's going to take to resolve this case, I can actually sometimes come up with creative legal ways to accomplish that the school district is willing to agree to. But if I don't know that ahead of time, I can't accomplish that. And if you don't know that going into the meeting, if you haven't really sat down and looked at your list and you don't realize that is the thing that I really need to push, then you might find yourself going, 10 rounds over whether or not they're going to provide, the text to speech or a reader, when you actually don't care about that much. If that is something that you don't care about, obviously just using that as an example. So definitely definitely make your list before an IEP meeting, before a meeting with the school, but consider, okay, which of the 3 umbrella categories does this fit into? Does it fit into more of the I'm willing to let it go, or is this the thing that I'm willing to fight for tooth and nail? I'm willing to go to due process over. With that, those are my tips, but I would love to take some questions if anyone has them on these, or any other kind of like legal landmines in advocating for students in schools.
Okay, so I don't have any questions coming from the audience yet, but I want to give them a chance to do that. There is the Q&A section on the bottom. If you hover on the bottom of where Caitlin's sharing her screen, you can ask the questions, type them in there. Alternatively, you can put them in the chat and send them to me, all the presenters. And if you are dialing in via the phone, once again, *6 will unmute you. But I may have to mute you again depending on any feedback. So we have our first question, which is asking if we're going to send the PowerPoint to members in the meeting. And we are going to be sending that, as well as a PDF outline that Caitlin has graciously prepared for us. So the answer is yes. That is coming your way. I can actually answer that one. So those were the first 2 questions we had. Anybody else have any questions? And if you don't feel comfortable asking the questions, I'm not going to say any names of people asking questions. And I'm also, if you don't feel comfortable asking them as a call-in listener, please feel free to email info@ldaamerica.org and ask the questions. And Caitlin said that she will answer those as well. I have another question. Do you have any thoughts about the pros, cons of parent support groups, talking to parents within the district as advocates?
Yeah, I think parent support groups are wonderful. Both the support groups that are sometimes started within the district and also more informal support groups. A lot of districts where I work have parent support groups that are sponsored by the district. And I think that that's great when districts are able to do that. Understandably, I think that sometimes discussion can be somewhat stifled when, when the there's representatives from the district there. But I think that actually those district-sponsored support groups can sometimes address problems more quickly. So, I know of situations where parents have come up with concerns and then been able to have them addressed by the district representatives that are at that support group. On the other hand, I think that the confidence that's built in a group of parents where there's maybe not district staff present can also be really valuable. And I know of a number of groups that have started in areas where I practice where they'll meet like every other month. They typically have a speaker for the first half of the meeting or the second half of the meeting, depending on how they're structured. And a lot of times that could be an advocate or a related service professional, somebody who can bring sort of an outside area of expertise. And then there's an opportunity for networking because a lot of parents can benefit from each other's past experiences. The flip side to that is I do find that some of these common stumbling blocks that I talked about are ones that have been shared between parents. So I have had some parents say to me like, oh, and then I worked with another parent who had withheld their evaluation, and she told me to do the same. So I do think sometimes we can share misinformation that way, but that's why I really like the model of parent support groups where they do have occasional speakers, because I think that can kind of shift the ideas some. And then the final point that I wanted to mention is if you're bringing a parent support person with you to a meeting. So like I know a lot of parent support groups where parents end up working with each other and will sometimes help support each other in meetings. I think that that's awesome because a lot of times meetings can feel really overwhelming. And so if you have a peer support person or a parent support buddy to come with you, I think that that's great. But I just suggest to tell the district ahead of time. I think sometimes a parent feels like, why should I have to tell them? And you don't have to tell them. But it's just a courteous thing to do. So going back to that mentality of trying to be a firm but kind parent, I think it just sets a tone of, look, I'm not trying to hide anything. I'm coming with a support person and I value this person's support and I'm allowed to bring them. And so I want to make sure there are enough chairs at the table.
Awesome. We have two more questions coming. First one is, have you ever dealt with a case where parents wanted a personal aide, but the school did not support this decision?
Yeah, so I see that a lot. And I think that there are different ways to try to work on this. An aide is obviously a huge expense for a district. And I think a lot of districts also worry that an aide may make a student stand out from their peers. That's a reason that I hear a lot of times for not providing an aide. And these are some of the, in situations where I really do feel the aide is warranted based on the input from, the experts, the either independent psychologist or therapist or, whoever's working with the child. The ways that I try to explore that are a couple of different things. One is to make sure that there's a plan in place to scale back the aid. So obviously, we're looking for independence to the greatest extent appropriate. So if a student is starting with an aid, but we think that it's appropriate to work on scaling that back, set benchmarks for when you would expect to see that support be pulled back and what that would look like. So once the student, I gave the example of social interactions because I do work with a lot of students with social needs. So once a student is independently initiating social interaction without prompting by the aide, then we would expect the aide or the personal support to maybe drop a class and not be sitting right next to the student, be observing and taking data. And kind of like doing a sort of, this is a goal that we want to meet. And then once we meet that goal, this is what we expect would be the scale back in service, and have a plan for that. So that way the district knows that the parent is also being independence minded, and the parent knows what the benchmarks are for kind of meeting that gradual plan to withdraw that support. Another, suggestion that I see commonly made and that I think is a really good one is to have the support person's primary but not sole responsibility be the student with a disability. And I think that can be a great asset to the whole classroom and to the student with a disability. So if Chloe has an aide, but that aide's primary responsibility is Chloe, but not sole responsibility is Chloe, then there's less of a stigma, because I know a lot of districts say that they're worried about the stigma that's going to attach. So there's less of a stigma because this aide is working with Chloe, but is also working with other students. And the other students in the class see the benefit of that person, and the person is more a part of the classroom. So that's another way that I can see that addressed. A third way is kind of what I was suggesting in one of the examples of ways that you can ask questions if you're one of those parents who might be more likely to be more of a pushover. And the example that I gave is, why don't we try this accommodation and take some data? You can do the same thing with an aide or with really anything else that you are asking for that the district is saying no to. So sometimes a compromise position is saying, look, I'm willing to not put this on the IEP right now. Why don't we call it a diagnostic measure? So we are going to put this support in place and take data on it, and it'll actually be an evaluation. So much like we, do a functional behavioral assessment or we do a psychological evaluation, this is an evaluation in and of itself. We're going to do a diagnostic support of the aide. We're going to take data on how it goes. We can take data on the things that the parent is concerned about that they think the aide will support, and we can take data on the things that the school district is concerned about that they think the aide will, somehow be a problem for, whether that's social interaction or whatever it is. And take data on it and see how that goes. So that's another way to kind of bridge that gap. Whenever that's happening, I just try to make sure that the training for the aide is going to be really good, especially if you are looking for that person to help facilitate social interactions, because I think that they do need some social skills training going into that position. And then also consult with either the speech language pathologist, school psychologist, or social worker, whoever in the school runs the social skills program. Similarly, if the aide is going to be really supporting the student with instruction, making sure that there's a consult service included in that diagnostic support, so that the aide can have opportunities to consult with the special education teacher and make sure that they're supporting the student in an appropriate instructional methodology. And then finally, and this is really more a tool that's available to an attorney than to a parent, but sometimes I see parents negotiate creative things. So sometimes I will negotiate having an aide provided as part of a settlement agreement. And the district says, look, we really don't think it's appropriate. We're never going to be willing to write it in, even in an evaluation form, but we will agree to provide it as part of a settlement agreement if you waive claims to pass compensatory education. And so sometimes that's a way that we can get it done.
Okay, speaking of social work, we have a question. I'm a social work student about to graduate. Congratulations.
Yeah, congrats.
Currently, I intern in school-based private practice.
Okay.
What kind of information documentation do you wish you could get from social workers in whatever capacity they're working with the child? And how can a social worker provide support for parents and children going through these issues in a school?
Awesome. So I would say not unique to social workers, but I would maybe especially for social workers, I really do like to see data on the goals that the student is working on. So if you're working on particular goals with a student, it's really helpful to see the data on how they're doing on those particular goals. I also think it's really useful. You had mentioned what supports do you like to see for parents? I really like to know kind of how skills that the social worker is working on are being generalized by the student. And so making sure that homeschool communication is there, and where necessary that there's a parent training component. I think that parent training, which for those of you who don't know, that's it's actually a related service under the IDEA. It can go on an IEP. It is, I think, one of the most underutilized services, but one of the most useful ones. And I think it can be useful from both a parent perspective and a school perspective. So a lot of times I think it's useful for a parent to observe what any provider is doing, a special educator, a related service provider, but especially a social worker, to see kind of how they're working on things with the student. And if observing the direct interaction with the student is going to not be productive, at least having maybe a 30-minute meeting each marking period. It doesn't even have to be a lot, but to learn some of those techniques, I think can be really useful. They say that Mr. Rogers was teaching children as much as he was teaching parents how to interact with children, and that a lot of what he did was model good, parenting skills in teaching with children for parents. So, and I still get a lot of that out of watching Daniel Tiger, which is the new spinoff of Mr. Rogers. I think they do a great job of modeling how to talk to kids through difficult situations. And it's not something that that comes to us through any sort of manual that the hospital gives us when we give birth, or that, the child comes with. It really is, I think, a skill that social workers have, that other professionals have, that we can really benefit from. So I think that piece especially is actually really useful, and proposing parent training as a support to parents is one that I would love to see more often, because I think we as parents really benefit from that information and knowledge that we can get from you.
Okay, and in the interim, we've got a new question. What concerns have you seen families have with regard to transition planning, particularly transition to post-secondary settings?
Great. Wow, so many concerns. We actually just spoke on this at the LDA conference, the national conference, transition planning generally. So a few things that I think can be great to work on for transition planning, especially if they're going to a post-secondary school setting, but also a post-secondary work setting, is really understanding their own rights as a person with a disability and knowing how to advocate for those rights. A lot of times our students in high school don't understand that it's going to be on them when they get to college to seek out the Disability Rights Office. It's going to be on them to know their rights when going through an interview process with an employer. So I think that is a really important piece of transition planning, and one that's often not given enough attention to. I think that's a great goal to include in the transition planning section of any IEP. Also, making sure that a student knows what agencies are available to them when they leave the high school setting, and knowing that the Office of Vocational Rehabilitation, which every state has, is a resource to them at that point. And then finally, I think preparing for that other setting as much as possible in high school, through sometimes hybrid programs if we can. So if a student is going to be working, finding a community-based partner who would be willing to take on an intern, and if they need a job coach, ask for that to be included in the IEP. It's much harder for a school district to say no to a job training program if a parent finds a community business that is willing to take the student on as an intern with a job coach, and learn those skills. And they could do that at the beginning or end of each day instead of whatever their last block would be. And that's great. Life planning, it's resume building. It helps teach them a lot of skills, and a lot of things will come up more organically in those scenarios that the school district job coach can work on with them than may come up in simulated situations in school. Similarly, if there's a local community college where a student with disabilities can start taking classes while they still have the benefit of the high school support team to help them, know, okay, your first day of classes, we are going to help you write a letter to the Office of Disability Supports asking for student notes, or the middle of the semester, we're going to start preparing you to ask for your testing accommodations. Those are really great things for a student to go through as part of their transition plan while they're still in high school before they get to the collegiate or post-secondary setting.
Okay, and we have another question. Do you have any advice on how to obtain a fair chance commensurate with one's potential for a student with a high IQ but large educational discrepancy for a student with IEP? He's performing well this year, good, decent grades. The school's trying to remove all supports, which are finally working and allowing him to succeed.
Whew. Yeah, so I'm going to restate the question, and hopefully I'm understanding it correctly. But if it seems like I'm answering the wrong question, obviously please write in again. So it sounds like this is a student who has a high IQ, but is achieving below what their intellectual potential would be. So we may be talking about a student with an IQ in the 120s who is achieving on standardized achievement tests in the 100 range, which would be a significant discrepancy between their achievement and their intellectual potential, but would mean that their achievement scores are in that average range. And without being like totally boring professorial and getting out of my lane and talking too much about school psychology, I won't get into the whole question of eligibility for an IEP under a learning disability and the significant discrepancy model, because I think we could do a whole other webinar on that. But I will talk about strategies for maintaining supports for a student in that situation. And I think some of it depends on what the district is calling those supports. So if those supports are in an IEP and the district wants to scale some of them back, then I would do kind of like we were talking about with the aid and, ask that there be benchmarks. So say, look, I'm not opposed to scaling back supports, but I want to see it done as a graduated approach. And I don't want to see support scale back until certain benchmarks are met. So, what is the goal for this student academically? And not just their grades, because a lot of kids with high IQs can kind of outsmart the assessments, or maybe they're just, they're really hard workers. So their homework is there, their class participation is there, and their tests aren't there, but that's not what the grades are based on. So I'm not thinking just about grades. I'm thinking about their actual achievement on their IEP goals. And on standardized measures of achievement, and saying, okay, once we see these benchmarks, then I'm willing to scale back the supports to here. And then let's get another benchmark and scale back the supports to here. So, kind of accepting the premise that the district is putting forward, but saying that you want to see the data to support it. A tougher situation can be if the supports are through response to intervention. So what I will sometimes see is a student, let's say, for example, with dyslexia, who is receiving research-based instruction through the response to intervention model. They have not been identified as needing an IEP, and they're actually doing really well in RTI because maybe the district is doing a really good job of implementing their reading-based, research-based instruction. Maybe they have a Wilson program or a Lindenmuth-Bell program. All of these are good research-based programs that could be implemented through RTI. And then if the student is responding, they're viewed as not qualifying for an IEP. And the parent is saying, I don't understand. She has dyslexia. A program that is proven to work for kids with dyslexia is working for her. Why is that saying that she doesn't qualify for an IEP? And the short answer is that RTI is working, so maybe more supports aren't needed. And a lot of parents are going to be satisfied with just that. What they really want is the sound research-based programming. And as long as that programming is there, they're not concerned about making sure that that it stays there. The problem arises when the school district says, okay, so this student has made enough progress in RTI and we're going to take them out of it. And a lot of times I'll see this happen for maybe like late elementary age students who are starting to make some progress in reading, and their parents feel, oh, they're just on the cusp of not needing this anymore. Why are we taking it away? So, in those situations, I think that there are different tactics to use depending on your own district. If it is an RTI situation, making sure that you got, appropriate notice before the service was dropped. If they haven't been evaluated yet for an IEP, ask for a psychoeducational evaluation and say that you want included as part of that evaluation the RTI data, and that you want the student in my hypothetical example I was referring to as you want her to continue in the RTI program so that data is available as part of the psychoeducational evaluation. If they are talking about scaling a program back that's 5 days a week to less than that, saying, okay, well, what is the research basis for this decision? Because RTI is supposed to be a research-based program. They're supposed to be implementing interventions that are proven to work for kids with, various learning needs. And so what is the research basis for delivering this program fewer than 5 times a day or 5 times a week, 30 minutes per session? Because the majority of the programs that they're going to be using have strict protocols for how they're delivered. And so saying, what research supports your decision to scale this back and deliver the program in a way that's not commensurate with in line with the research. So those are just a few strategies, that I've seen utilized and that can be successful. Obviously, different situations could call for different forms of advocacy. And one of the kind of best resources is looking at your procedural safeguards, and then, as we talked about earlier in the presentation, maybe going up the ladder. Because sometimes I have seen services scaled back when it was done in a way that was maybe not appropriate. And when a parent went to the building special ed coordinator or the school district special ed director, they were told, oh, actually that service should not have been discontinued. So that can be another resource.
Okay. And I can actually answer the last question. It's just, will the lecture and Q&A be available via recording later? Yes, I am attempting to get it out within 24 hours, barring any technical issues. So yes, that will come to you via the email you signed up with. So no worries there. And that was our last question. So I'd like to thank you for taking an hour out of your day and probably more preparing and joining us and giving a great webinar. Thank you so much.
Thank you all so much. And thank you, Erica. I hope everyone's well.
Thanks. Have a good night, everyone.